spike right in the first 60 days. Yeah.
Just excited.
Go after the cheer.
I have a feeling like I can tell you like a couple of people across the city. Yeah, I think so. I don't know. Well, I know I consider looking for people. And then just saying I want to stay here, but my family's here. So. Yeah, but she's already there. I think she'll stay. Oh, did you get the notifications? Yeah.
Okay, we'll begin shortly. Please silence your phones. All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're here today in our case, State v. Gonzalez. That's 1 CR12-0773. Each side will have 20 minutes to argue, and appellant, you may, save time for rebuttal, but you'll have to manage your own time, where the clock is. We're recording the argument, both in audio and video. And what we're doing new this term is we're putting them on YouTube, so you can be a YouTube star. When you approach the bench, please identify yourself so that when we listen to the argument, we know who is speaking. We've read the briefs and we've conferenced the case, so we know the facts of the case, and we're familiar with your argument. So please begin.
Thank you, Judge Howe. May it please the court, counsel. We're presenting three issues for the court's consideration today, and unless the court directs me otherwise, I think I'll address them in the order that they've been briefed.
Sure.
Initially, our first argument is that the verdict forms in this case were both incomplete and confusing, and although they were in compliance with Rule 23.2, it's our position that in a case such as the one before the court today, a case with multiple charges involving the same offense alleged to have occurred on the same date, Rule 23.2 is patently insufficient to protect against fundamental error.
So counsel didn't raise this issue below when it could have been solved easily?
It was not raised, Your Honor, and I know that the appellee has cited Rule 21.3c. However, 21.3c does not apply in cases of fundamental error.
And how is this fundamental error?
Well, we believe, Judge, that based upon the record in this case, it's evident that the jury was clearly confused, having convicted on count 2 as opposed to perhaps count 3, where there seemed to be much more powerful evidence presented in the trial court.
Well, but how do we know
Well,
what the jury is thinking when they look at the evidence? You may believe, I may believe that the evidence is stronger on one charging us than on the other, but that's not for us to decide.
Well, we don't know. And all we can do as lawyers and judges is look at the record and try to figure out if we believe that something went awry, and it's our position that that's what happened in this case. The trial attorney, defense counsel, attempted to bring this to the court's attention, but not until the time of the sentencing, at which time he requested that the trial court reconvene the jury to address what he believed to be this potential discrepancy in what may have occurred. The trial court elected not to do that and went forward and sentenced the defendant on the charges for which he was convicted.
Counsel, let me ask you, on what authority would the trial court have to reconvene a jury 30 or 45 or 60 days later to ask about what they deliberated about?
I haven't been able to find a specific rule, Your Honor, but I think that the trial court has inherent powers to do that. I think the trial court can do what it sees fit in the interest of justice to try to correct what might be a significant error in the procedure.
But let me ask you, because that getting to the admissibility, that would be governed by 24.1 admissibility of juror evidence, and as opposed to the rule of evidence that applies in civil cases. And it seems to me that even if it had been raised in a way that could be done, and even if the court agreed to bring the jurors back, that what they testified to would not be admissible to consider the motion for a new trial. That's what, and I've got some other questions before we even get to that point, but even accepting everything you say as true, I still am not sure from an evidentiary perspective how the court could properly consider such information.
Well, I'm not sure it's an issue of evidence. Is it perhaps just an issue of attempting to clarify if they understood which count belonged to which?
And I guess that gets inside the jury box or in the jury room, and it seems to me that that's really not what trial courts do.
I cannot disagree with that, Your Honor. I think it's a difficult situation. I don't know that there's any specific remedy in our rules of procedure that would address this specific situation. But it appears to me that what defense counsel attempted to do was perhaps the only thing he could have done at that moment in time.
Let me ask, and I understand your position on that, but didn't defense counsel also in closing make the distinction using the to-wit that the charging document used, that candidly, had the verdict form use that, you wouldn't be arguing this point, there'd be no point to argue. But can't we look to closing arguments as in sort of the cluster of things that a jury properly can consider? I
believe that we can, and I think that the state cited some case law to that effect. But the jury is instructed, as we pointed out in our brief, that the arguments of counsel, are not evidence. They're not necessarily anything other than argument, and the jury doesn't have to consider the arguments of the two attorneys at the trial.
And which is fair, but the request here, I think that you allege should have happened, wouldn't have been evidence no matter what. It's really a clarification in how the jury should treat two different forms of verdict for different counts that otherwise read identically.
Right.
Is that fair?
It is.
And you had mentioned, to me, when I initially looked at the briefs, and I want to hear from both of you really on this question, that when the jury, acquitted on one of the two counts that read the same and convicted on the other, that suggests, with no questions, best I can tell, from the jury during deliberation, that suggested they really weren't confused. That if they'd convicted on both, that if I were in your shoes, I would like that record somewhat better, not on behalf of your client, but to argue that there was confusion, we just have no idea here. But you've taken a different approach. Help me better understand that.
Well, of course, if they convicted on both, then, I don't know that would strengthen our position in this. It seems to me that, based upon the record again, there seemed to be overwhelming evidence on the other count by comparison to what was testified to and presented on the count for which they convicted. Based upon reviewing the record, we believe, and I don't know that there's anything else I can point to. We certainly can't get into the jury's minds, but it appears to us that they were confused and perhaps they convicted on the other count.
So, counsel, is the only reasoning that you believe the jury was confused was because they convicted on one and not the other? Is that the only fact in the record that leads you to believe that they were confused?
I certainly think that's perhaps the best fact. I think to go through the analysis, we do have to look at the evidence. And the evidence on count two, for example, Annabelle testified, quote, he tried to put it in me. And then following a blatantly leading question by the prosecutor, which was, did it go in a little bit? She then responded, a little bit, yeah. So that was a testimony on the count for which they convicted. On the other count, she testified that he penetrated her vaginally and she thought he was never going to stop. So that, to me, that's much more powerful. And it seems to me that that's much stronger evidence when you're comparing what happened here.
Thank you.
But isn't it went in a little, why isn't that sufficient for the, and I know this kind of gets into your second argument.
Yes, sure.
But why isn't that sufficient for the jury to have found him guilty of count 2 and of the anal penetration?
Yes, Your Honor. I think that it's insufficient if the trial court would have gone through the same analysis that the Arizona Supreme Court went through in the Torres case. In that case, the child testified that she was raped. And then the trial court went through an analysis where they reviewed on the record on appeal and looked at the other evidence in the case. And the other evidence, much like what happened in this case, indicated that there was no bleeding, no injury, no bruising, and that the doctor did not examine the child as if she had been raped. In our case today, similarly, there was no corroborating evidence of any biological evidence. The only evidence in the case was from the child's testimony, either in court, what we've just discussed, or her hearsay testimony that was allowed in through the testimony of the SANE nurse with respect to her examination of the child.
And counsel, that's not sufficient?
Well, I think if, in response to Judge Orozco's question, with respect to the statement in court, I think it's insufficient based upon the Torres case. I don't see how it can be distinguished from that case, really. She's saying it went in a little bit in response to a leading question after she testified. He tried to put it in. He tried to put it in. She said that twice. I believe that would be insufficient, certainly. And so if the court's going to go through the same analysis that the court went through in Torres, I think it casts great doubt on her testimony that it even went in a little bit. And under the standard of substantial evidence to support conviction, I don't believe it meets that standard.
How else would the state prove that it went in, other than by her statement?
Well, certainly, perhaps through some corroboration, physically through the examination. She was examined approximately 12 hours after this is alleged to have occurred. But notwithstanding that, there was zero biological evidence. There was no semen, no seminal fluid, no DNA, no pubic hair found that tied Mr. Gonzalez to this case. And that, in today's world, seems highly unlikely. Now, the SANE nurse also failed to swab the child's anus, perhaps much like the doctor in the Torres case decided not to conduct an examination.
So are you saying that the jury was required not to credit her testimony?
I'm sorry, Your Honor?
Are you saying that the jury was not? Are you saying that the jury was required to not credit her testimony because there wasn't corroboration?
No, I'm not saying that, but I'm saying that when the trial court's asked to assess the case under Rule 20, there has to be some weighing of the evidence by the trial court. And we believe that based upon the evidence in this case, it was insufficient. It did not meet the standard of substantial evidence that would require the court to grant the Rule 20 motion.
Thank you.
And lastly, we briefed the issue that's been litigated a few times before. Most recently, this court rendered a decision in, I believe it was State versus Jones, July of this year, with respect to the issue regarding the apparent conflict between 13705 and its predecessor and 13116, Arizona's statutory prohibition against double punishment. And once again, this court has rejected each and every one of the state's arguments that 13705M trumps in some fashion 116. The court pointed out in Jones that initially that the characterization of 13116 as a general older statute must yield to the more recent specific 13705, as argued by the state, was without merit. The court recognized the purpose of 13116, which is to prohibit double punishment, which, as we know, is the statutory codification of the prohibition against double punishment under our state and federal constitutions in cases where a single act is in violation of two statutes but should not be punished consecutively. And once again, just like the court did in 1993 in the Apoldi decision, the court rejected the state's argument. The court recognized that under rules of statutory construction, they're required to attempt to harmonize the two statutes, which I believe they were able to do. They didn't see the conflict. They simply concluded that in cases involving dangerous crimes against children, where 13705 requires consecutive sentences, those must be imposed, provided that the consecutive sentences do not violate 13116. And in this case, the state, much to its credit, has conceded that it's a single act. The kidnapping could not have been committed apart from the greater crime of sexual conduct. It's all part and parcel of the same incident. And so for those reasons, this court now has twice decided that consecutive sentencing is not appropriate in cases such as the one before this court. Looks like I have about 2 minutes left. I'll reserve that for rebuttal.
Thank you,
Thank
counsel. Mr. Matthews?
May it please the court, I'm Joe Maziarz, Chief Counsel of the Criminal Appeals Section of the Attorney General's Office, representing the appellee state of Arizona in this matter. I plan in my argument this morning to briefly address the first two issues. Quite frankly, I think they're thoroughly covered in our answering brief, and I'd like to spend the majority of my time, questions permitting, focusing on the third issue, particularly in light of the court's recent opinion in Jones. Regarding the first issue, the verdict forms, obviously, as noted in the brief and it's conceded by appellant, this claim is reviewed only for fundamental error. Appellant did not request any factual specification in the verdict forms, and the verdict forms fully comply with Rule 23.2C, which requires only that they specify each count, and they in fact did that, and they specified the offense. Now, there's no duty for the trial court to sua sponte include in the verdict form factual specification. Appellant cites the Jacobs case, And in that case, the Supreme Court said essentially the same thing, that, yeah, you don't have to have any factual specification, but it's not error if you do so. And in fact, in Jacobs, the trial court did not have factual specifications regarding the kidnapping offense in that case.
Counsel, let me ask you, if instead of 2 counts, there were 10 counts with the same elements committed on the same day, allegedly by the same defendant, would you be making the same argument?
Yes, I would. I think in that situation, it's quite likely that both the state and the defense would have asked for factual specification. And I have no doubt.
We'll get to that in a second.
Sure.
But as a legal matter, should we sort of assume that there is absolutely no confusion and that even though this could have been easily avoided, that that's just fine?
Yes, I think unless there's error, and there's simply no error. Now, appellant claims the rule is insufficient, but the remedy is to petition the Arizona Supreme Court to modify the rule to require specification in the situation you're suggesting.
Well, let me ask, the state didn't ask to use the 2 wits that were in their charging document in the verdict forms. Is that correct?
Correct.
And the defendant didn't either. I mean,
No.
that's why
No.
we're here. But wouldn't that be a really easy thing to avoid this whole thing?
Absolutely. And I have no doubt that had appellant requested that, it would have been done. The state would have said, fine, go ahead and do it, and the trial court would have accommodated the request.
Could the state have requested that too?
Certainly. But you got to bear in mind, this was an all or nothing case. And this gets into why the alleged error is not fundamental.
Ask you, why, if it's an all or nothing case, why would that matter as to whether the verdict forms, if they could be easily clarified, and I think everybody agrees that they could have, why that wasn't requested?
Well, because, again, I think from the defense's perspective and from the state's perspective and from the view of the trial court, it was an issue of credibility. And besides that, there were some, as noted in the brief, some problems with the investigation, to put it mildly in this case. And there was really no issue of whether the jurors might convict on one count or the other, at least in the view of the parties in the trial court.
Although not in the view of the jury.
Well, we don't know why. It may well have been juror
compromise. We know the outcome. We don't know the why. You're right.
Right. So it may well have been juror compromise given the problems of investigating this case. We simply can't delve into the mental processes. And Judge Thumb, I think you pointed out, Rule 24.1D precludes that. That specifies the instances in which you can make inquiry into juror misconduct, and it specifies the grounds, and certainly this is not juror misconduct. So clearly here there's no error. That should end the inquiry. But even if we go on to the next 2 prongs of the fundamental error analysis, it's clearly not fundamental because it had nothing to do with appellant's defense. It didn't go to the foundation of the case, deny him a right essential to his defense, or make it impossible to receive a fair trial.
Would it have made a difference if if his defense differentiated on the count?
Not legally, no, because again, the rule doesn't require that. Now, if that were the case, we're talking hypotheticals, I think it's crystal clear the parties in the trial court would have had that factual specification, though not required in the verdicts. And moreover, both counsel would have, in closing arguments, differentiated between the counts. But again, that wasn't the defense here. That wasn't a concern here. We've also pointed out that the error is not fundamental because factual specification had nothing to do with his defense. In closing arguments, he differentiated between the counts. As noted by the trial court, the jurors had pad and paper and could take notes during the trial. The indictment was read to the jurors. There were no questions during deliberations regarding the distinction between the counts. And finally, I think, far from prejudicing appellant, he claims that the evidence on count 2 is weaker. Well, now he's in a position where he's actually benefiting because he can challenge what he perceives to be the weaker evidence on count 2. So simply no fundamental error, no prejudice in this case.
Counsel, is it appropriate to ask your counterpart if it was appropriate for this court to look at closing arguments in assessing the case? Do you agree that it is?
Yes, it is, and I believe I've cited a couple of cases in my brief. And in that instance, I think, Judge Thummer, you pointed it out, they're not arguing evidence. He's simply saying this is count 2, this is count 3. That's not evidence. He's simply clarifying for the jurors each count, and the state never took issue with that.
And let me ask you, and I understand the state's position is, first and foremost, there was no error, and as an alternative, that if there was no fundamental error resulting in prejudice. But wouldn't the better practice be to include the to wit in the jury forms?
I think so. And again, I think had either party or the trial court thought that this was at issue or that the jurors could possibly be confused, which of course we don't know that they were. I haven't got to this yet, but I don't think the evidence on each count is that much different. These kind of things would come up, and the trial court, I'm sure, would have accommodated the request of either or both parties, but that, in this case, that simply wasn't at issue. Briefly regarding the sufficiency of the evidence, appellant, first off, this is clearly a question of credibility. The victim testified on direct examination that he penetrated her a little bit. And I'd also point out in cross-examination, appellant's counsel went into more detail regarding the anal penetration. And he actually, for some reason, and I'm not sure why, focused considerably on that in cross-examination and even prefaced some of his questions by saying after he performed the anal intercourse or during the anal intercourse. So it was strengthened by cross-examination. Also, of course, we have the nurse's, not only her relation of the statements by the victim, her written report came into evidence without objection, which included unequivocally the victim's statement that he penetrated the anus. So there's clearly sufficient evidence on count 2. Appellant mentions the Torres case, which he cites in his brief, and quite frankly, I read that yesterday. Probably should have done it earlier, but in Torres, there was no evidence whatsoever of penetration. In fact, in his opening statement in that case, the prosecutor told the jurors, we may have a problem proving penetration, which, seemed rather odd since that was what the defendant was charged with. And sure enough, during trial, no evidence of penetration was ever presented. It was just a rubbing. And on appeal, the state all but conceded the issue in its brief in that case. So that's far removed from the situation we have here, where the victim unequivocally testified there was penetration, but only a little bit. And along those lines, there's no physical evidence to corroborate that, but Nurse Jill Rabel testified that in less than half of the cases where anal penetration is reported does she ever find evidence of that. And in this case, since the victim testified there was minimal penetration, we would expect not to find any evidence to corroborate that. But certainly her testimony alone is more than sufficient. I'd like to turn to what I believe is the most interesting issue in this case, particularly in light of the court's recent decision in Jones. I think there's no question, if you read ARS Section 13116 and 705M, they're both unambiguous and they're both in conflict. The issue becomes which of the two controls. And the well-established rule of statutory construction is a more recent, more specific statute controls over a general, older statute. It's our position that Arnoldi and Jones were wrongly decided, and they're based on clearly erroneous principles. Arnoldi relied entirely, and there's no analysis in Arnoldi, it relied entirely on State v. Noble, Arizona Supreme Court case, which had nothing whatsoever to do with this issue. In Noble, the issue was whether consecutive sentences could be imposed for multiple offenses committed on the same occasion. And in fact, in Noble, the offenses were committed before the effective date of the Dangerous Crimes Against Children statute, which requires mandatory consecutive sentences. And in that case, all the Arizona Supreme Court said was, yes, you can. It overruled Mullally and Perkins, which had previously held that when offenses are committed on the same occasion, consecutive sentences could not be imposed, recognized that only applied to enhancement with priors, and said, yeah, you can impose consecutive sentences subject to 116 and what was then 708. And if the court will recall, back at that time, to impose consecutive sentences, the judge had to justify the reasons. Now, under 711A, that's flip-flop. But at the time, that's all Noble held. It didn't say that 116 was paramount. It simply recognized the law as it was at the time. In Jones, the panel followed Arnoldi with no analysis and added 3 additional points, each of which are clearly erroneous. First, it wrongly stated that 116 is not a statute of general application. Well, it certainly is. It's about as general as you can get because it applies to all criminal offenses, not only under Title 13, but also criminal offenses, DUIs, leaving the scene of an act, whatever, under Title 28. So it is very clearly the epitome of a statute of general application. Jones also erroneously relied upon the principle of legislative acquiescence. And I've cited filed a supplemental authority pointing out that the Arizona Supreme Court has clearly held that that doctrine applies only to decisions of the Arizona Supreme Court, not to decisions of this court. And quite frankly, for some reason, Arnoldi for the last 20 years has flown under the radar until the Jones case. In this case, we had a very experienced prosecutor, experienced judge, and even defense counsel all agreed that sentences had to be consecutive. They were simply unaware of Arnoldi. It's flown under the radar. But more importantly, the doctrine of legislative acquiescence doesn't apply.
Well, Counsel, you were at the AG's office in '93 when Arnoldi came out. Wouldn't legislative fix be a lot easier than arguing uphill as the state seems to be?
Well, you know, and I'm sure I read Arnoldi, but I don't remember it. I don't remember the holding, at least in this regard. Could we have gone to the legislature and clarified it even more? I suppose if we wanted to, but I think you've also got to recognize it really applies in very limited situations. We clearly, if there were 4 or 5 acts, one after the other, no problem with consecutive sentences. It really applies in the unique situation where you have a kidnapping and it's solely for the purpose, as in this case, of restraining the victim to commit the offense. Or in Jones, it was a unique situation where you had the child abuse and the child abuse felony murder. And under the statute, they had to be consecutive. And I also might point out Jones is up on review. Who knows what the Supreme Court's going to do with it. But yes, that could have been done, but Arnoldi's just flown under the radar. I don't know why it is. Until Jones, 20 years later, I think most people were either unaware of it or didn't appreciate it. That's the only thing I can figure, because I've seen cases over the years where consecutive sentences have been imposed in these situations and no one even challenged it. So I have no explanation for why Arnoldi hasn't been really recognized until recently, but it's clear there is no analysis, so it's clearly erroneous. I think you have to really look at Jones.
If the Supreme Court denies reviewing Jones, will the AG try to fix this issue?
I don't know. It's such a narrow issue that I hate doing legislative things. So personally, I really wouldn't want to, but APAC or the county attorneys may decide to do something regarding that. I'd be speculating to say they would or wouldn't.
Yeah, so let me ask you, you've cited a couple other cases, a couple other factual patterns where the paramount nature of 116 was addressed. There's a third that you haven't mentioned, a case called State versus McDonough from this court in the DUI context earlier this year. Don't those cases, and they come in a variety of different factual contexts, they really do come up with some frequency, not every day to be sure, but don't those collectively view 116 as kind of a uber statute? In other words, the tie goes to 116 unless there's language that just isn't present here, like notwithstanding any other law or something akin to that.
I was going to get to that point in a minute, but I'd like to answer the question regarding McDonough. McDonough was a situation where we took the position that consecutive fines were mandated, and quite frankly, it was a weak position because it was at best ambiguous on that point.
Completely different factual setting. I absolutely agree, but in some respects, doesn't that show that that the Arnaldi concept, and there are cases that deal with it, could be at least a little more broadly applied than just in the factual context of what we have here.
I don't like to refer to the Arnaldi. I think 116 is
Yeah,
essentially paramount unless there's opposite legislative statement, which we have here. It says, shall be consecutive to any other sentence imposed at any time. And the final point I was going to make, and it's a point that Jones makes, is exactly what you just mentioned. Why didn't the legislature say notwithstanding any other provision of the law? Well, I think the reason is obvious, because the legislature is presumed to be aware of 116. It's presumed to be aware of the rule of law that a more recent, more specific statute controls, and it would be simply redundant to state the obvious, that we realize this is going to trump 116 because it's more recent, it deals with this very narrow class of offenses, and we know that it's going to control. I think what's more probative, and in preparing for argument, I did a little more research, is there are several places in Title 13 where the legislature uses the terminology except as otherwise provided by law, which makes more sense because the legislature obviously is aware of the fact that this newer statute would apply but for limiting language. And one of those places, interestingly enough, is 13.711A, which deals with precisely the issue of consecutive sentences. Now, that's the statute which says, we call it a default statute, that sentences are going to be consecutive unless the trial court specifies concurrent and gives its reasons. But it starts out by saying, except as otherwise provided by law, if multiple sentences of imprisonment are imposed, blah, blah, blah. That is a recognition that, but for that limiting language, it would trump 116. And so I think given...
Well, let me ask you, though, don't the cases require for something to trump 116 that the statute say something like notwithstanding any other provision of law? I mean, it's not just... You're citing, as I hear you, and let me ask before I forget, you are not conceding that there's any constitutional restriction. This is solely a statutory interpretation.
Right, we're dealing solely with statutory construction.
There are legislative or statutory construction principles that look at when you have two sort of co-equal statutes that appear to be inconsistent, how do you reconcile them? And your argument, I suppose, would be these are co-equal, but they're not even inconsistent, right? But aren't there also statutory construction principles that are time-worn, where one statute is deemed to be sort of the hub of the wheel, and then you have to, in other words, are not co-equal statutes?
Not that I'm aware of. The principal rule is, if you look at the two statutes and they have mandatory language, which both do here, and they're in conflict, which they are, the principal rule is the more recent, more specific controls.
And I understand that, and that I get that from your brief, but that's not the only statutory construction principle that could apply here.
I believe it is. I believe that's the cardinal rule of statutory construction in this situation. Now, you try to harmonize statutes where possible, but that's when there's some kind of ambiguity. These statutes are unambiguous, both of them, and they directly conflict. The principal rule of statutory construction in that circumstances is the more recent, more specific controls. And again, I think given all these circumstances, it proves that both Jones and particularly Arnoldi were based on clearly erroneous legal principles and should not be followed. So in conclusion on this issue, 13705M is clearly the more recent and far more specific of the two statutes and controls over 116, and therefore the trial court did not commit fundamental error in imposing consecutive sentences. Now, unless the court has any further questions, I'd ask that the court affirm the convictions and the consecutive sentences imposed by the trial court.
Thank you, counsel. Counsel?
Just briefly, a couple of points I'd like to make. The verdict forms issue. One other thing that I think may have been confusing, and I'd just like to have the court recognize this, is that the counts 1, kidnap, 2, anal penetration, 3, vaginal penetration, were not in order in terms of the sequence of events. They were flipped. 2 and 3 were flipped. So I think that may have led to some of the confusion, and I'd just like to point that out to the court. With respect to issue 3, the consecutive sentencing issues and some of the remarks by the state, I would disagree that 13116 is a general application statute that, as counsel suggested, applies to all criminal cases. In fact, it's a very limited statute because it only applies to those few cases where somebody's convicted of more than one offense based upon a single act. And that's a very rare set of circumstances, I believe. And so I don't think it is fair to throw it into the category of some general statute that's been trumped now by some new or more specific statute. I think the statute's very specific with respect to the evil it's intended to protect against, and that's double punishment for one act, which is, at the cornerstone of our judicial system. So those are the only 2 points I wanted to comment on. I would ask that the court reverse my client's convictions and the consecutive sentence and remand this matter to the trial court for further proceedings. Thank you.
Thank you, counsel. We'll take this matter under advisement and we stand adjourned. Thank you.
You too.
Don't work too hard.
How many times do you come down here every year?
No, I haven't been in over a year. I've probably done 75 or 80 over the years, but.
Yeah.
And I can.
Hey. It's going pretty good. It's just day and day.
So
Is that your new secretary? Yeah, my pages. Yeah. I just started doing the habeas work earlier this year, so mostly pro se stuff, so trying to construe the arguments. Yeah. Tell your family said hi. And Dave, he didn't come, right?
No,
I'm sure.
No, I was in class.
Take care. Good to see you. Yeah.
we had to come down here like